Hello, everyone. Welcome to our webinar, or my webinar, on Understanding California Coronavirus Eviction Moratoriums. This webinar is primarily for a commercial real property, not residential real property, although some of the rules that I will be talking about do apply to both residential and commercial. During this webinar, I will be talking about the various orders, rules, and regulations in California that affect commercial landlords, tenants, and property managers. There are statewide rules and executive orders, as well as county and city regulations and ordinance. And there are also, I might add, excuse me for scratching, I shouldn't be touching my face, I guess, as well as court rules that are relevant and affect all kinds of evictions. Due to time constraints, I will not be able to mention every city and county in the state of California. However, I do intend to focus on the statewide eviction limitations, commonalities between the various state and local rules, regulations, and ordinances, and areas where there are differences between the various jurisdictions. Probably of more importance, I will give you my take as to what all of this means and what you should be paying attention to, whether you are a landlord, tenant, or property manager. This webinar is for anyone who owns, leases, or manages commercial property in California. We will not be discussing multi or single family residences, as I've previously mentioned, since evictions relating to these type of properties are considered residential evictions. I am not providing legal advice in this webinar. My intention is to educate and inform. With this being said, I encourage you to contact me for assistance. As such, this may be considered attorney advertising. So let me first do something to introduce myself. My name is Howard F. Klein, Esquire. I've been an attorney for over 30 years, handling general business matters and with I'd say, special emphasis on commercial real estate leasing, including lease negotiations, evictions, and rent collections. Let me also mention that about a week ago, I decided, because I'm in the position to do this, that I'm going to give back to the community and give a major league discount to my services for those people who need help negotiating rent relief. Big or small companies, landlords or tenants, property managers, it doesn't make any difference. Now, here's what I'm offering. Normally, I charge $395 an hour for any of my lease work, transactional work. What I'm going to be charging is $100 an hour or $1,500 for a flat fee up to 25 hours. Now, this is kind of important. This offer is limited because I'm going to be doing everything myself, and I don't want to be in the position where I do a schlocky job. This offer is limited to the first 60 leases that I work on or where I have been retained by or before August 1st, 2020, whichever occurs first. I'm already getting a considerable amount of inquiries. This is over a 75% reduction. That's it. Let's get into the webinar. So before we get started, now I've got a PowerPoint. Now, normally I don't like to use PowerPoints. I want you to see my pretty face most of the time. My wife that annoys her when I say that, and I don't really blame her because I can see myself really well, warts and all. So we will get into the PowerPoint to help you along, and I will make that available as well as some of my notes. Now, some general concepts before we get started. In retail, I prefer not to serve an eviction notice and evict a tenant, particularly in a down cycle. No one wants to move into an empty shopping center. Now, I have negotiated and litigated leases through a number of recessions. And I learned a long time ago that if your knee-jerk reaction is just to kick people out because they're not paying rent, then there are some problems with that, and you end up with an empty shopping center, and it's really tough to then get people to move back in. Now, there's a caveat to that. If you have a replacement tenant, I'm okay with that. It's better, in my opinion, to keep a tenant in place even if they aren't paying rent. Now, this applies in retail. This might not hold true in industrial and office. At least in California, I find that many of the court remedies and the type of lawsuits that I file are much easier to prove and more quicker to collect rent. Now, that doesn't mean that an unlawful detainer doesn't move faster than a breach of lease lawsuit. But in a breach of lease lawsuit, if I've already terminated the lease by serving a 3-day notice, I have different remedies. One of which is a remedy where I don't have to deal with the mitigation argument, where I've terminated the lease and I'm trying to collect rent. My rent collection action is subject to the tenant's argument that the landlord has not adequately mitigated their rent. And for a lot of reasons, that causes all kinds of grief. Landlords who, for the most part, just want to get paid rent and they normally have a knee-jerk reaction and serve eviction notices without fully understanding the ramifications of serving the notices. They might, at this point, start reconsidering these options and not have a knee-jerk reaction, because it may be, if not impossible, to serve a notice, at least over the next few months. Now, let's get to the PowerPoint. So this gives you an idea of what I had to look at and what was involved in doing this research. There are 58 counties in the state of California and 482 cities. Keep in mind, not every county has created their own eviction moratorium, and not every city has. County ordinances apply to those areas of the county other than the jurisdictions that the cities have. City ordinances apply only to the areas within the city. If the city nor the county eviction, if there is no city or county eviction moratorium, the state executive order and the judicial council orders apply. Just so that you know, okay, these are some of the initial ground rules. I will tell you up front, I did not review every one of the 58 counties, and I did not review every one of the 482 cities. Just couldn't do it. And even if it's some huge law firm, they would not spend the time. But what I did do is I sampled, and I got a pretty good idea as to what's going on. All right. So let's talk a little bit what is more of a statewide moratorium. And the statewide orders are covered by Governor Newsom's executive orders and something called the California Judicial Council, which has promulgated emergency orders. Plain and simple at that point in time. I got to pay attention to my notes. Now, let's talk a little bit about the executive orders that are relevant. On March 4th, Governor Newsom declared a state of emergency. That is important because some of the county and city ordinances are tied into when that state of emergency ends. So we will hear more about that. Then on March 16th, Governor Newsom suspended any state law that restricts a local government's power to impose limitations on evictions. So let me go into a little bit more detail on that. Now, what's what was included in that was that the basis of eviction had to be based upon non-payment of rent or a foreclosure arising out of a substantial, here's the word substantial, decrease in business income caused by a reduction in opening hours or consumer demand, and the decrease in income was caused by COVID-19 or by any local, state, or federal response to the COVID-19 panic. And here's another important word, and is documented. So as you will find out later, if the county or city ordinance says the tenant doesn't have to document their loss of income, that's in violation of the governor's order. Now, the governor also in this order indicated that the right to evict a tenant after foreclosure is also suspended, because that occurs once there's a foreclosure. The owner of the property, who might be in the property, has to get out, but doesn't while this order is still in effect. And here's another important consideration. This is where it might cause some confusion. Nothing in the order relieves the tenant from an obligation to pay rent. Excuse me. The order is effective through May 31st, 2020. Under the circumstances, I suspect that the order will be extended. This, again, is going to be important as to what the parties are going to do and what the effect of the various local orders, ordinances, and laws are. Now, let me make something clear, and a lot of people don't understand this. An eviction action, an unlawful detainer action, they mean the same thing. It is for the purpose of obtaining legal possession of the property. Ancillary to that is the collection of rents due up until the time that the tenant is evicted. But that's only ancillary. If possession is not an issue, then an unlawful detainer action is inappropriate. Unlawful detainer actions are entitled to priority on a court's calendar. If you really want to collect rent, either through the end of the term of the lease or for a substantial period of time other than when the tenant was in the property, you have to file a breach of lease lawsuit. And there are different rules, and a breach of lease lawsuit doesn't have priority, but sometimes it can move faster, just so that you understand that. Now, let me tell you a little bit about the Judicial Council. All right. The Judicial Council is a policymaking body of the California courts, which is the largest court system in the United States, under the leadership of the Chief Justice of the Supreme Court and in accordance with the California Constitution. So the Judicial Council, I'm very familiar with it because they set all kinds of rules. They don't set laws. They don't create laws. That's up to the legislature. But they set these rules that sometimes often affect the laws and how we conduct business in the courts. So the Judicial Council, this was after the executive orders. Understand, the executive order of the governor didn't impose any kind of moratorium. But this is what the Judicial Council did on April 6th. What they did was they, in essence, banned evictions of tenants unable to pay rent because of the financial hardships of the coronavirus. And they did it by, one, suspending the issuance of a summons in unlawful detainer cases unless the court finds that there's a health and safety reason. Now, you could file your lawsuit, assuming that the court is accepting files. And right now in the county of San Diego, they're not. They're not even accepting paper or electronic files. But in order to proceed with the lawsuit and serve the tenant, you got to have a summons, which is an order. And without that, you can't really do anything. So in essence, they kind of put the kibosh on all unlawful detainers from April 6th on. It also, their orders also prevent the entry of a default or default judgment, again, unless there's a health and safety reason, and they add, and the defendant has failed to appear. If the defendant has failed to appear, that's when you can get a default and or a default judgment. But you can't even do that now. So if you have already filed a lawsuit and the tenant hasn't answered or otherwise filed some sort of paperwork, you can't get that default. So whatever had been existing, there's a kibosh on that. It also mandates trials in unlawful detainer matters to be set no sooner than 60 days after a request for trial. Now, let me tell you what the normal process is. The normal process is that you serve the tenant with a summons and complaint, and the tenant normally has 5 days, unless it was served by substitute service, but I'm not going to get into that. So normally the tenant has 5 days in which to file an answer. Once the tenant answers, anyone who requests the court to set a trial, the statute says that the court must set the trial date within 20 days of the date that the request to enter trial or request to proceed with trial has been filed with the court. So in this case, the Judicial Council is saying, you know what? At the earliest, it's only going to be 60 days, not 20 days, and it may even be longer. And if I were you, I would assume it's going to be longer, particularly if you have a jury trial. I'll get into that later. So it also, the Judicial Council rules also state that if anything, if there's an unlawful detainer where the trial has been set on April 1st or as of April 1st, it will be continued at least 60 days. At least 60 days. All right. You're going to get an impression from this, whether you're a landlord or a tenant, but you're going to get the idea that this stuff is really hard on landlords. And then they say that the rule changes are effective until 90 days beyond the date that the governor lifts the state of emergency. So right now, the state of emergency is set to expire on May 31st. So the earliest that anybody could do anything would be in September. Now, I will add, my expectations under the circumstances is that the state of emergency will be extended for some time after May 31st. So a landlord on a statewide basis is going to have a really difficult time taking any kind of action to evict a tenant for a long period of time. So let's get back to the slides. Our next slide is, all right, provisions that appear common. Now understand, I went through about, I think, 7 or 8 counties that had their own ordinances and about 20 cities that had ordinances. And I realized at some point in time I couldn't go on forever, but I got a pretty good idea of commonalities between the cities and counties and provisions. Okay. What is common in each and every instance is that written notice is, well, commonalities. Yeah, I think it's in each and every instance, written notice is required by the tenant. In each and every instance. I may be corrected on that, but if I recall correctly, every one of these ordinances that I reviewed required that. And as indicated by the governor's executive order, documented proof of substantial loss of business income due to COVID-19 or health directives or governmental orders in response to the COVID-19 pandemic. Now, I'll get into where there were some distinctions and differences. So I'm not going to raise that now. Another thing is, in every instance, the tenant still owes rent. Well, you might say, well, obviously they do. And that would be unless they negotiate something differently with the landlord. I'm not sure why the landlord would do that. I know during the last recession, a lot of landlords in desperation forgave rent, didn't have a clawback, or, didn't put in adequate provisions. And I unfortunately had to litigate a lot of those provisions in those leases. And there's no eviction for non-payment of rent if the tenant complies with the local ordinance. Now, the important part of that sentence is if the tenant complies with the local ordinance. Now, those are the ordinances, and that's the state governmental executive order. Whether or not you can still file based upon the Judicial Council orders, I don't really think so, but I could be corrected on that. I did want to mention that the Judicial Council and many of the state courts have indicated that if the eviction was based upon health and safety reasons, it can proceed. So, for example, if the tenant was required to put in fire detention or mitigation equipment, if it was in a kitchen, and they failed to do it, that might be adequate. There might be all kinds of other reasons. If the tenant had already vacated, but you had not evicted the tenant, you might be able to get access on something like that. And now I might add, and this is going to be important if you don't already know this, if not stated, I assume that as a matter of public policy, the ordinances will be liberally construed in favor of the tenant. Now, some of the ordinances I read did say that. They said flat out, this is going to be liberally construed. However, under normal circumstances, in an eviction, there's an old adage, the court abhors forfeiture, which means that if there's anything that the court could do to not kick the tenant out, it will. So any of you who are familiar with evictions, you'll know this. That's not that we can't get evictions, but you have to really dot your I's and cross your T's. And the other thing that is very, very common is document. From what I've seen, being able to document your need for rent relief is universal and will be required at some point in time. We'll get into what that point in time might be. And that's where we start getting into the differences between each of the jurisdictions. So let's talk about some of the differences. Well, one of the differences, if you recall, I mentioned that the tenant has to give a notice. Well, depending upon the jurisdiction, the tenant has to give notice at different times. All right. So in some jurisdictions, the tenant has to give notice before the rent is due. Anaheim is a perfect example. It says flat out, before the rent is due, you got to give notice. In some jurisdictions, it's not particularly clear. In some jurisdictions, it's clear that every time rent is due, the tenant has to give notice. So that kind of begs the question whether or not you can, as of April's rent or May 1st rent, you go to the landlord and say, I can't pay rent, and whether or not that notice is good enough. Los Angeles County and Beverly Hills, they state that within 7 days after rent is due, the tenant has to give notice. Some, San Diego County being an example, say that within 15 days after rent is due, the tenant has to give notice. And you will note that there's also a requirement of providing documentation. So in San Diego County, Yeah, San Diego County, I wanted to make sure it wasn't the city, get a little confused, that within 14 days after giving your notice, which is 15 days after the rent is due, you have to provide your documentation. And in some instances, such as the city of San Bernardino, you have to give your notice within 30 days of the date that the rent is due. But at the time that you give notice, you have to provide your documentation. Now, when is the documentation required? Well, this again varies from jurisdiction to jurisdiction. For example, Beverly Hills and Santa Ana allow the tenant up to 30 days to provide written documentation to support its claim. That would also include the city of San Bernardino. The county of San Diego, I had already mentioned, it really would be 29 days. That's if they gave notice within 15 days of the date that it was due. In some jurisdictions, I'm going to throw this out, late fees cannot be charged or collected during the moratorium. Some jurisdictions give the tenant time to pay back the deferred rent, even if the landlord has not agreed to a schedule. Okay. So this is what I consider the landlord killer, because if the tenant goes to the landlord and does everything that they're supposed to do and the landlord doesn't respond, then in some jurisdictions, the tenant still has time in which to, continue to not pay rent, and then has plenty of time to respond to it. So, for instance, Los Angeles County, the tenant has 6 months in which to repay the deferred rent. The city of Los Angeles is 3 months, but that 3 months commences from the date that the mayor declares the emergency over. Well, let me ask you this question. When do you think the mayor of the city of Los Angeles is going to declare this emergency over? Do you think it's going to be June 1st? Do you think it's going to happen just like that? I don't think so. Beverly Hills, you're going to love this one. Up to 1 year, 12 months. I read the language. It was a little bit weird in the ordinance, but it seemed pretty clear to me that tenants have up to 1 year to pay it back. Oh my gosh, that's great for tenants, but what about landlords? Anaheim, 4 months. Costa Mesa, 4 months. The city of San Diego, 6 months from March 25th, or the date would be not August. It would be, let's see, March, April, May, June, July, August 25th. Yeah. So in all of these instances, and this is what's so important, because when the landlord is considering negotiating rent relief, they have to be aware of these things. And the tenant needs to be aware of what's going on. Otherwise, they may be giving things away that they don't necessarily have to. Okay, and it's important to note that in some jurisdictions, the time to repay begins at the end of the state-declared state of emergency, and some from on or after May 31st, and some when the local emergency has ended. So I can't give you a definitive how long the tenant has to repay. So that's something to consider. Okay. Well, let's move on. We're still talking about the things that are different from jurisdiction. In some instances, tenants are excluded. So in some jurisdictions, not every tenant gets the benefit of this. For example, in the city of Beverly Hills, this moratorium applies to publicly traded entities, companies that are listed on the Fortune 1000, entities that have more than 500 employees, but not included in the exclusion is a franchisee or similar small business owner. All right. Now, I suppose I understand why they're doing this, but even if the city of Beverly Hills, there was a publicly traded entity, because of the Judicial Council rules, you may not be able to file. You'll be able to file, but you may not be able to get a summons. Not likely to be able to get a summons in an unlawful detainer matter this month or next month. So, having the right to do something is not the same thing as physically being able to do that. What may make a difference, for instance, is if the tenant is a company that is excluded, if they're not paying their rent, as soon as the emergency order is ended, they're going to have to pay it. They don't have the right to the extended period of time of 12 months as provided by the city of Beverly Hills. Anaheim and the city of San Bernardino require the tenant to pay that portion of tenant's rent that they can afford to pay. In the city of San Bernardino ordinance, it specifically says it will apportion. So in the evidence that the tenant provides to the landlord, if the tenant is still earning money, then, but can show that, for instance, its business or its income or revenue has dropped 15%, well, then it needs to pay 85%. All right. And then the question is, if they don't, well, they don't get the benefits of the moratorium. There are some jurisdictions that I have seen that have indicated that they will not even allow the service of a 3-day notice. I think under the circumstances, unless you can tell me in the chat, I don't see what the benefit is in serving an eviction notice right now if it's not enforceable as to the rents owing right now. Now, of course, that may be something worthwhile if the tenant hasn't complied. So serving the notice might speed things up when you can start getting your summons. And here's another important one. Some jurisdictions allow lockouts if the landlord had obtained a writ of possession and lockout order prior to the effective date of an applicable moratorium. So if there was a writ of possession that was given to the county sheriff, in some counties, they can lock out. All right. So that's something to consider. Now let's move on to, let me take a break and look at the chat and address some issues. Kevin Carter. Hey, Kevin, can an agreement between tenant and landlord, example, rent relief, supersede the emergency orders? Can they be more restrictive on tenants? I think might be the question. And the answer to that is maybe. Yeah, I haven't seen anything that has said that you can't do something more restrictive by agreement. That's maybe. I think in most instances, what we're seeing is, for example, let me give you an example of something that might, Michael, this is all commercial. Let's say the tenant and landlord entered into a rent relief agreement, and that agreement provided that the tenant has 3 months to repay the rent, or 12 months, or whatever it is. If it's 12 months and it's in I haven't seen anything in an ordinance that says more than 10 months. So the question then is, if you say 3 months and you're in a jurisdiction that says that the tenant has 6 months, probably the ordinance would prevail. All right. This is why I'm going to be telling you that before you just enter into these agreements, know what it is that you're doing, understand this stuff. Let's see. You mentioned that serving a notice to pay rent or quit has consequences. Oh, yeah. Other than giving the tenant the option to quit, do you think that there are consequences to service a notice to pay or quit if you don't follow with a UD complaint? Many years ago, I wrote an article published in the LA Daily Journal based upon a case that said that if the plaintiff dismisses the action, before it goes to trial, the plaintiff is not obligated to pay attorney's fees, but the plaintiff may be entitled to pay for some of the tenant's costs, which generally would be far less significant than attorney's fees. Some of the consequences, just to repeat, of serving the 3-day notice is for the purpose of possession. You've actually if you served a 3-day notice to pay your rent or quit and the tenant doesn't comply, you've terminated the lease. If you've terminated the lease, there are generally 2 different statutes that you will actually only one statute, which allows you to not only sue for rent that is accrued, but to sue for rent through the end of the term of the lease. But the consequence of that is the tenant gets to argue that the landlord has not adequately mitigated its damages. And in the lawsuits that I've been involved in under those statutes, that's about 75% of the cost and the delay of that litigation. And honestly, landlords have a tendency, and their property managers and their brokers tend not to have really good records. All right, maybe that's changed, but that's where my concern. If you don't terminate the lease, you can sue for rent as it accrues. In a down cycle like we are here, you could also go in and get a prejudgment writ of attachment tying up the tenant's money. And you could do that generally very quickly, although you may not be able to do it as quickly under these circumstances. And that's usually during a down cycle my favorite way. So if I get, for instance, if I sue for rent as it accrues, I know that's going to take a year to a year and a half before I get into court. So I can go in within a month and ask the court to give me a prejudgment writ of attachment. I convince the court that it's most likely we're going to be successful, and the court will not only give me the amount of rent that we anticipate will accrue, depending on how long it will take us to release under bad circumstances, and will also give us our anticipated attorney's fees, which could amount to $150,000, $200,000. And then I go ahead and I can do all kinds of stuff with that writ of attachment. That tends to make the matter move really quickly and get you your rent quickly. So that's my way of generally doing it. But that works better in a down cycle. And you have to pay attention. If basically you got a tenant who's not paying you rent and you have a replacement tenant, then we get rid of the tenant and we get the new replacement tenant in as soon as possible. Let's see. What is the time to pay back rent deferred in California? It depends. Throughout the state of California, there is no time period. It's up to the jurisdiction. And as I indicated, some of the jurisdictions, it varies from nothing to 3 months to 12 months. So you need to know your jurisdiction and what's going on. Actually, what happens if you're in a city or county that does not have its own eviction moratorium rules, it defers back to the state rules. And the state rules have nothing right now that says how long the tenant has to pay it back. So what does all of this mean? Now I'm going to be talking from the perspective of the tenant. First of all, you better have your financial records. And if not, you needed to gather them yesterday, right? Those records are immensely important to your ability to ultimately take advantage of this eviction moratorium. The records need to be accurate and understandable, and you may need to maintain these. And I would recommend that you maintain them in a separate file. Now, you might ask what kind of records. In some cases, the type of records are actually set forth in the statute, but I think that these would be normal financial records. Frankly, it would be bank records. It would be if you have a general ledger, if you have a profit and loss statement, if you have tax returns. I'd be a little cautious about turning over tax returns, but that may be required. Anything that's going to show that you took a hit. That's even if you're a restaurant, because most restaurants, no one's going to be surprised if you took a substantial hit. All right. But you still have to have your records. And the small mom and pops have a tendency not to keep good records. I've got a civil litigation matter now where we're piercing the corporate veil. We're alleging alter ego. And I asked the defendant, I'd like to see all of your financial records. And the defendant went, I don't have any. Well, you know what? That takes me a long way into proving an alter ego. If you don't have financial records, you're in trouble. So you need to start moving. What are the notice requirements? Well, here you need to know what the requirements are in your city and county. That's where these notice requirements are going to be set forth. So you need to know someone to do this. You need to know what type of notice and when the notice must be given. As I indicated earlier, sometimes it has to be given before rent is due. Sometimes it has to be given each time rent is due. Sometimes it doesn't have to be given until after rent is due. So you have to know this stuff. Do you have to provide documentation at the time that you give notice? Well, in some cases you do, and in some cases you don't. As I said, you need to know what's going on in your city or county. That's why you hire an attorney like me. Communications. Email is allowed. All right. So in nearly every instance, you can, even if the lease says that it has to be personally delivered or certified mail or overnight carrier, according to the ordinances, for the most part, email is allowed. If you ask me to check the ordinances of a county or city that I haven't yet reviewed, frankly, I would double check that to make sure that that's accurate, but it allows for it. But even if it allows for email notice, I'm a little uncomfortable with that. Sending something out, certified mail, return receipt requested, might be difficult because people might not be around in order to accept it. An overnight carrier might be better because there'll be proof of delivery. And that's one of the things that I like to do, particularly when I'm serving a pro per. You really should communicate constantly and often, and be honest and transparent. I believe that's how you're going to get your best results. Now let's talk about the landlord. If you're a landlord, this webinar is hurting you. I would start out with knowing what the requirements are in your city or county of where the property is located. This is as important for the landlord as it is for the tenant. And you should know this before you even negotiate some sort of rent relief. You need to make sure that whatever you're doing in the rent relief amendment does not contradict or be affected by a local ordinance. You need to communicate often with the tenant. So the property manager should be calling the tenant on a regular basis. You need to maintain your records. Absolutely. You need to consider negotiating the best deal going forward with the tenant. And here's one of the things. If you know what the statute and the ordinances provide, then you have a better idea of what you can negotiate, and you try to negotiate a better deal that might take some things back or might the negotiation is a give and take. So maybe both parties are in the position to benefit each other. But again, you better know what's going on in your locale. And another option would be consider a suit to collect rent rather than eviction. If the city or county ordinance allows the tenant to pay back deferred rent over a period, will the court order the payment sooner? Well, that was a question I answered before. I doubt it. So, for instance, in the county of San Diego, as I indicated, you can't file any document at least through May 22nd. All right, so you really can't do anything unless it's a health or safety issue. In other counties, such as Orange County, you can file the lawsuit. All right. And you can file a lawsuit to collect rent, but you may not be able to get that rid of attachment early. And that's unfortunately, because all of this is new, I'm not really sure. I would have to reconsider it, but a writ of attachment is extraordinary relief. And I think the courts might be reluctant at this point in time. And this all begs certain questions. I should have moved forward on this. And whoops, we don't have to go there. This begs certain questions, and I've asked myself certain questions as part of my analysis. Should the landlord or tenant negotiate and agree to rent relief? I think the answer to that is yes. You should negotiate, look for something better than what the ordinances allow for. Right. And I mean, if you're going to be consulting with an attorney, you might as well give me a call. You need to maintain good and transparent relationships. Here's a good question. I don't know. I'm going to look at the chat, but here's some of the questions that I've asked. What does the landlord do if the tenant does not give proper notice or provide adequate documentation? Okay. Well, you may not be able to file an eviction lawsuit. You may be able to file a suit for breach of lease and get that rid of attachment. Because if you're able to prove that the tenant did nothing, didn't give you a notice, didn't provide you documentation, the court may be inclined to give you that rid of attachment because the tenant would not be entitled to the deferment of rent. You may not be able to evict the tenant right away, but you may be able to get that rid of attachment, and the tenant may not be entitled to the extended period in which to pay it. So if I were negotiating a rent relief agreement on behalf of the landlord, I would put in some sort of language that would pay attention to that. Next question that I asked myself. Unless the landlord has an overwhelming reason to consider eviction, the landlord may want to affirmatively contact the tenant in writing and notify them that they have not fully that the tenant has not fully complied. It depends upon the situation. If you've had a bad tenant before all of this happened, you may not want to smarten them up. If you basically have a good tenant, and depending upon what the regulations are and the payback period, you may want to tell them, hey, you need to provide me this stuff. Or you may want to just do it separately, which begs then another question. If the tenant comes to you and informally sends you an email saying, I can't afford to pay rent, and then you ask for all kinds of financial information separately in order to negotiate, does that trigger the tenant's, and they provide the information to you, does that trigger the tenant's compliance of the local rules and regulations? Maybe. I think that's something to consider. Unless the Judicial Council emergency rules are changed or terminated, landlords cannot file an eviction action and get a summons. All right. Now, what happens if the landlord had already filed an eviction suit before the effective date of the emergency orders and ordinances? Well, if the summons had already been issued, I didn't see anything that said that the landlord could not serve the tenant with the eviction complaint. If they do so, however, understand that the tenant will have 60 days to respond rather than the normal 5 days. After the tenant responds, landlords can request trial to be heard, which will be no sooner than 60 days after the landlord has requested it. This must be smarting those landlords out there. If tenant doesn't respond in a timely fashion, landlord cannot take a default or obtain a judgment or do anything else other than sue for damages. All right, and I can see something else happening here. And finally, what if the landlord has already received a judgment and a writ of execution for possession? Well, as I've indicated, we'd have to check the local counties and cities, but it appears that not all counties have prohibited sheriffs from executing on the lockout order. So that apparently can still happen depending upon the locale. So before we end this, there's some other questions here. So Jordan says, I think if the agreement is entered into subsequent to the emergency order, then yes, you can supersede the order, but that may not get around an eviction ban, so the enforcement eviction. Jordan, Jordan is saying that you can enter into a separate agreement. I'm not sure that that's true as it relates to the local county and city ordinances. That may be something that remains to be seen. I think, though, it's a good question. John Hines, is there a way to invoke the right to collect rent as it becomes due if the lease does not specifically provide for this remedy? I should know the answer to this. I think the answer is no, because normally what I see is that the lease will provide the landlord's right to seek 1951.4 damages and allow the landlord to take possession. But I'd have to double check that. John, I am sorry. I should know that answer. Off the top of my head, maybe it's because I don't know the name of Myanmar or I don't know. You caught me flat-footed. But John, I will provide that answer afterwards. I know that under 1951.2, which is suing for rent as it accrues, I think it has to be stated in the lease. Now let's see. I've got another question here. For smaller retail tenants, they want to provide Governor Newsom's orders and state ordinances that non-essential businesses be closed. Is this documentation enough for? No, absolutely not. I think that the Governor Newsom's order has indicated. Now, if the city or county doesn't have an ordinance, certainly Governor Newsom's order provides that you need to provide documentation showing your loss of business income resulting from COVID-19. I'm not going to go into the detail on the words. So just saying, oh, this is what the order is, that's not good enough. And this is what fries me sometimes. Some of you may have been around when I was previously talking about the offer that I made. I've actually had some tenants approach me and say, great offer. Thank you very much. I'm thinking about taking you up on that offer, but I think I'm going to handle it myself. And I'm just going, at that price, what is wrong with you? So, yeah, you might have a tenant who thinks that they know things, who thinks that they can do things, and doesn't want to spend $100 an hour or $1,500 to save a $20,000 a month lease. Well, they might think that, and they may just give out this this is what the governor's order says, and think that they complied with the executive order or their local ordinance, and they haven't, and they may have given away big time rights if they hadn't given their documentation in a timely fashion. So technically, a tenant could go 5 to 6 months without paying rent before a landlord can get anything done. I think that if the tenant fully complies with the applicable ordinance or executive order, they may be able to go 5 or 6 months before they can be evicted. It is possible that if they fully complied with the executive order and the ordinances, it may be 5 or 6 months or longer before you can get rent. If they haven't complied with the order, you may be able to collect sooner. But I would say at the very earliest, you're not going to be able to get an eviction until September. All right. And then at that point in time, and keep in mind and that would be at the very earliest, because the Judicial Council order indicates that these rules will exist for 90 days beyond the end of the governor's emergency order. And as I said, the governor's emergency order currently ends on May 31st. But I wouldn't be shocked if Governor Newsom extended the order another 3 to 6 months, in which case, man, we got to come up with a solution for landlords, because this is going to kill landlords. This is not sharing the pain. This is basically asserting the pain. And I'm going to be coming up, I believe, in 2 weeks with a webinar on foreclosure rights, and this is relevant to landlords, mortgage relief, and foreclosure moratoriums, because it's very relevant to all the landlords who are hurting themselves. So, you set the table for further research. Yeah, I have to do further research also, Ted. It's really scary. And I reiterate again, I'm doing this because I'm offering, I'm looking to pick up more business to help people out, and I'm offering a huge discount. And I think it would be smart if you know anybody who wants to, just doing the research alone is different. One of the things that I experienced is in doing the research on this and preparing for this webinar, all kinds of questions came to my head. And then after I did the research, I said, I really have to think of all of these other questions, and I have to contemplate what landlords and tenants can do in the best way of doing it. If you're capable of doing it, great. If you're not capable of doing it, if you don't have my expertise, oh, please take advantage. $100 an hour. I haven't charged that since the 1970s. And it is limited. People will be taking me up on that offer. So with that being said, I'd like to thank you all for attending. When I have this available to share, I would appreciate it if you would share it to everyone that you know and refer anybody to me. It's good form if you think that I can help out. Well, at the end of this, I guess I will do a final thing here, go to the slides. And the final thing is how to get a hold of me. My phone number is 949-954-6699. You can send me an email at hfklaw.com or connect to me on LinkedIn. I'm going to be having a series on how to sell for landlords, tenants, and brokers on LinkedIn. Not just market, but sell, because I'm re-educating myself on this stuff. So this is going to be good stuff. Thank you very much. Please be safe and stay healthy. You have a great day.